I'm going to go back to one of the things that Joshua shared with you, which is, again, U.S. Constitution, Article 1, Section 8, which is the IP clause. I just want to start here because IP is crucial to protecting what you own in the cultural and the creative industries and making money from your original works. Copyright is particularly important for the creative sector because it allows creators to protect the creative and the expressive parts of their work and to control how it's used by others. And as Joshua noted, patents and copyrights have their origins in the IP clause of the Constitution. And here it is on our slide here. And I go back to that, and I always start my copyright classes and my clinic classes with students with this, because I just think it is so, so fundamental that the founders, the drafters of our Constitution, when they were doing things like putting in powers to create militias and to mint money and to start the postal system. And they were all farmers and fishers and, were getting their hands dirty with things like hunting and farming. They sat down and they thought, what do we need to include in the Constitution? And they thought, we need to include powers to protect the exclusive rights of authors and inventors. What kind of forethought does that present? That they realized way back then that our country was actually going to build such wealth on the creative endeavors of individuals who create and think with their minds and create such wealth for our country through their innovation and their creativity. So that's why I think it's worthwhile emphasizing the constitutional origins of those protections that you all have. So what's required to have copyright? You need an original work that is fixed in a tangible medium. What does that mean? An original work. So an original work is something that is independently created by a human, but it does not need to be novel. It doesn't need to be something that nobody else necessarily could ever have created. So one example that people sometimes suggest is if you have two poets working in obscurity on opposite sides of the country and they happen to come up with exactly the same poem, as long as they didn't have access to each other's work and didn't copy from each other, they would both have an original work that could be copyrightable. That doesn't typically happen, but theoretically that could be possible. The work has to be created by a human. Why do I mention this? You may have heard in recent years of stories of the monkey selfie, but that is less likely to happen, although I will tell you I have a cat that likes to take selfies of himself and has done so in the past. But what is more likely to happen over the next several years and several decades, and you can come, as Joshua and Sean mentioned, to our conference in October and hear more about what people think might happen in this space, is that works will begin to be created by artificial intelligence. And what will that mean for their status as copyrighted or copyrightable works? That's something yet to be determined. But for now, work needs to be created by a human. Ultimately, as I said, it needs to be fixed in a tangible medium. And what does that mean? It can be a photograph. It can be something that you set down in writing, either on your computer or pen and paper. It can be recorded somehow. You can film it, you can transcribe it. What is not fixed An example of something that's not fixed could be choreography, some dance moves that have never been notated or filmed. An extemporaneous speech that has not been filmed or recorded, a sketch or musical composition or improvisation that has not been recorded or transcribed. Those would be examples of things that have not been fixed in a tangible medium and would not meet one of the requirements for copyrightability. But other than that, if you've got an original work, you are a human and you've created it and you've fixed it in a tangible medium, you've met the requirements. You don't have any other formalities that are required. You don't actually have to go and register the work at the Copyright Office. As long as you've set it down on some form of, tangible medium, you automatically have a copyright. You can go and license it or transfer it or assign it to somebody and start, building a business with that work. But even though it's not required, no formalities are required, I strongly urge you to register your work with the Copyright Office for a variety of reasons. There are a lot of benefits that you get from registering a work. Some benefits are that it will allow you to protect your work better. First of all, it's required to register your work if you intend to bring an infringement lawsuit. If somebody infringes on your work and you want to enforce your rights, before you file a suit in federal court, you must have a registration certificate from the Copyright Office before you file an infringement lawsuit. There are also various benefits in terms of the presumptions that are accorded to you in court if you have a valid registration certificate from the Copyright Office. Furthermore, if you have registered and if you've registered in a timely basis, meaning you've registered either within 3 months of publication of the work or before the infringement occurs, you have the ability to get statutory damages and attorney's fees if you find yourself suing for infringement of the work. And finally, it also creates benefits for you in terms of creating a public record and facilitating licensing transactions in your work. So it creates a benefit not just for you as a copyright owner, but it creates a benefit for the copyright system as a whole, because people can find you and people can more readily engage in what the copyright system is intended to do, which is promote progress and dissemination of knowledge and copyrighted works. So let's talk about copyrighted works and copyrightable subject matter a little bit more specifically. There are a variety of categories that copyrighted works fall into, and I've listed them here. You can have literary works, musical works, dramatic works, pantomimes and choreography, pictorial, graphic and sculptural works, motion pictures and audiovisual works, sound recordings and architectural works. Those are the types of subject matter that are protected by copyright. There are also various types of things that cannot be protected by copyright. And some that are very important to be aware of are that ideas and facts cannot be protected by copyright. And I'm just checking to make sure that we don't have a comment here. I see Joshua's back, but I assume we'll just continue with copyright and have Joshua come back once we're done with the copyright discussion. So ideas and facts are important to distinguish as things that cannot be protected by copyright. A lot of times people are under the misimpression that if they think of something, some great idea for a storyline, some great idea for a motion picture, some great idea that they want to turn into a copyrightable work, that idea is itself protectable, but it's not. It's only the expression of the work that you ultimately write down or capture in a tangible medium that is protected. In some cases, there may only be one way or a very limited number of ways to communicate a particular idea. And copyright law then says that the idea is merged with the expression, and neither is protected because there's only really one way to express that idea. So that's a limitation on copyright protection. Another limitation on copyright protection is this doctrine called cens of faire. And to put that into English and common terms, copyright law doesn't protect things like stock characters or settings or events that you would commonly expect to occur in a particular subject matter or area. So for instance, if you are writing a novel or filming a movie about a treasure hunter, you cannot protect the concept that treasure is hidden in a cave and the cave is full of snakes and the treasure hunter uses a fire to repel the snakes. And the treasure hunter is crawling through a tropical forest and is startled by some jungle beast that pops out of the forest. Or you can't, protect the concept of a weary traveler, going into a tavern for a respite from his search for the treasure. All of these things are common stock elements or stock settings or events that you might imagine would pop up in this sort of a setting in a novel or a film, and so those would not be protectable under copyright law. Similarly, things like words and short phrases are not protectable under copyright law. So things like names, whether it's your name or your business name, perhaps your band name, or your brand name, none of those are protectable under copyright law. Neither are character names or the URL of your business, or catchphrases, or lists of ingredients in a recipe. None of those things are protectable under copyright law, but you'll see when my colleagues talk about other types of IP protection, you may have protection under trademark law or trade secret law for those types of products or types of property. Another exception or limitation under copyright law is government works. And here I'm talking about US government works, federal government works. So anything that's created by the US government, federal officers or employees of government agencies or the government's judiciary branch, as well as Congress or employees of the DC government, none of those are protected works under copyright. A couple of things to be aware of here as well. This applies to federal government works, not state works. So be aware of what the protections are with respect to state works. The federal government can hold a copyright in certain works that were made for hire for the federal government work or transferred to the federal government by somebody else by virtue of a license that they've taken. And there are a few agencies that are kind of special scenarios here. So the US Postal Service, the Public Broadcasting Service, and the National Public Radio are not considered government agencies for purposes of this. And you can see why that might be, because they create so many creative and artistic works. The Smithsonian Institution is also something to be wary of here, because the Smithsonian Institution is kind of a split agency. They're half private and half federal government funded. So if the Smithsonian Agency creates something, you need to know whether it's been funded by the private part or the public part before you know whether it's subject to this or not. So what are the rights that you get if you are protected by copyright? Copyright gives you certain exclusive rights, and they fall into two main categories. So they're easiest, I think, to think of as either economic rights or what are sometimes called moral rights. The economic rights are basically, they break down into giving you the right to authorize or do yourself certain things. And copyright is often, when you talk about it, discussed as a bundle of rights. And sometimes people even talk about it like, imagine if you have a bundle of sticks and you can give those sticks away to whoever you want, and you can charge prices for the sticks and give those sticks away on, whatever terms you want to give them away to whatever party you want to give those rights away to. And that's maybe an easier way to envision the fact that you don't have to give everything away at once when you're talking about a copyright. So the types of things that you can do, imagine you have written a novel, and you are talking about what economic rights you might have with respect to this novel. So the types of things that you might be able to do with these economic rights that you've been granted under copyright, you have the right to do things such as make copies, authorize derivative works, distribute copies, make performances, or make displays of the work. So imagine you've written a novel. What could you do? You could prevent others from making copies of your work while you yourself make and distribute copies of the work, or enter into a license agreement with a publisher to help you make and distribute copies of the work. You could authorize a trusted collaborator to make a derivative work of that novel, such as a film, or maybe a translation of the novel. You could also perhaps license your rights to somebody like a producer of a audiovisual work, of a film, to further authorize the broadcast of the film embodying your work. And that work could then be communicated to the public, including by making it available online, through Netflix or other video services, or on demand. And you, the producer, could authorize the renting or lending of physical copies of the work. You could do all of this for profit, while at the same time, you could have also retained for yourself certain rights. For instance, the right to license the work for performances, for charitable purposes, for instance, to benefit nonprofit groups that you might want to allow to use the work for for their charitable purposes without a fee. So you can imagine the various ways you could divide up and authorize various parties to use your work uh, under different circumstances and for different fees. The second set of rights, these that are categorized as so-called moral rights, are personal to the author. And those are rights that we're less familiar with in the United States, although we are technically required to have them in the United States. But these are rights that people are much more aware of in the European countries. And in the United States, we think of them more commonly when we're thinking of notable works of visual art, like paintings. So those rights fall into basically two categories, integrity and paternity. So the rights, moral rights of integrity are rights that basically allow the author to challenge any changes that are made to a work that would negatively affect the author's reputation. The other category of rights are referred to typically as rights of paternity or rights of attribution. And those are the rights to be credited when a work is either performed or displayed in public. So I won't go into too much detail on those because, as I say, those are typically limited to visual artworks and notable visual artworks in the US. One other area that is quite often talked about is fair use, and that is a doctrine that is developed in the United States through case law. It's talked about as an affirmative defense, which means it's what you can plead in court if you've been accused of copyright infringement. And if a court agrees, you will be excused of the infringement. So if something clearly qualifies as a fair use, this also means that you don't have to seek or obtain a license for the use. The tricky thing, the challenge here, is that fair use is something that's determined by courts on a case-by-case basis, and it's a situation where a court applies the law to the specific facts of your case to reach a conclusion, whether it agrees, whether what you've done is, qualifies as a fair use or not. And so the things that the court will evaluate when determining whether something is a fair use or not are these four factors listed here. The purpose and character of the use. So they'll look to things like whether what you're doing when you're using somebody else's work in your work, they'll look as often to whether it's a commercial use or a nonprofit or educational use. This isn't something that's dispositive. If you're using something for a commercial purpose, that doesn't mean absolutely that, it's not a fair use, but it's something that the court will evaluate. On the flip side, if you're using something for an educational purpose or a nonprofit purpose, that's also not a get out of jail free card. On the flip side, it's simply one of the four factors that will be evaluated. There's also no bright lines here necessarily. So, and people oftentimes have misimpressions of what qualifies as a nonprofit use or as a educational use. So for instance, people think that if they're using something in a classroom context, that automatically qualifies it to be an educational use. So for instance, people sometimes think, well, I'm a teacher, I copied an entire chapter of a book or even an entire book for all of my class, it's an educational use. I'm using it to teach. No, that is not a fair use. It's not, it doesn't qualify for all of the other factors of that a court will evaluate. So you must be careful as you're going through the test to carefully evaluate all of the factors and take all of the circumstances into account. Similarly, simply because something is done in the context of a school setting doesn't make it an educational use. So for instance, if you're putting on a